Welcome. Thank you guys for being here with us on a Saturday afternoon. My name is Manju. I am a journalist. I'm a graduate student here at Stanford. I'm also a volunteer with BACCS, which is the co-host of today's event. And this event is co-hosted by BACCS and CAA, Chinese for Affirmative Action. And we're here to talk about something that affects many of us directly, which is immigrant rights and recent shifts in immigration policy. And BACCS is a platform for interdisciplinary learning and public dialogue. We host talks and roundtables to foster connection and thoughtful conversation, both in person and online. You can find more about our work by following our website and Instagram, and we encourage you to donate to us to help us stay free and open to public. And in recent weeks, immigration has been in the headlines, from revoked student visas to scientists being turned away at the border. And I think these incidents raise serious concerns about how we as immigrants or non-citizens can protect our rights and stay safe. So today we're joined by an experienced immigration attorney who will walk us through what these changes mean and offer practical advice for different visa and immigration situations. And the talk will be in English with AI-assisted Mandarin translation, followed by a Q&A. And before we begin, I would like to invite our co-host at Chinese for Affirmative Action to introduce today's speaker and also share a bit about their work. Please welcome our friend Jinsha.
Thank you. Welcome, everyone. So my name is Jinsha. I'm a digital engagement manager at Chinese for Affirmative Action. Many of you have received an email confirmation and invitation from P.L.ba, that's the Chinese fact-checking website here. At the same time, we are also managing Justice Patch website and Chinese American Chat WeChat public accounts. It's focused on amplifying the accurate information and progressive narratives on racial and social justice issues in Chinese American community, particularly on immigrant rights, economic justice, and other education-related issues. So we are very lucky that we are affiliated with Chinese for Affirmative Action, a nonprofit organization in San Francisco, and we are very happy today. We have our executive director, Vincent Pan, is going to start with how, what's the San Francisco policies, movements, and resources that protect immigrant community, and how Chinese for Affirmative Action, our organization, has been involved in these movements. And of course, we're very grateful, deeply appreciate that we have our senior attorney, Olivia Lee. And another thing is that Olivia is also our board member. So it's really deeply appreciated they are able to make the time and to support this event. So without further ado, I will just invite our executive director, Vincent Pan. Thank you.
Good afternoon, everyone. Like Jinsha said, my name is Vincent Pan. I'm the co-executive director of Chinese for Affirmative Action. And before I get started, it always helps me just to have a sense of who's in the audience. So I'm going to ask a question. If it applies to you, you can raise your hand. You don't have to, but it'll just be helpful for me. So if you are currently a student, either here at Stanford or somewhere else, if you could raise your hand. If you are currently a worker somewhere in the Bay Area, if you could raise your hand. If you have grandparents that were born in the United States, if you could raise your hand. If you have parents that were born in the United States, if you could raise your hand. And then if you were born in the United States, if you could raise your hand. And then if you were not born in the United States, if you could raise your hand. That's really helpful information. helps us understand a little bit about who we all are. Chinese for Affirmative Action, we're a civil rights organization, and we were founded in 1969 in San Francisco, Chinatown. And this was a time when Chinese Americans were still seen as perpetual foreigners, and Asian Americans were largely invisible in the fight for civil rights. CAA's mission is to protect the civil and political rights of Chinese Americans and to advance multiracial democracy in the United States. That means we fight discrimination, expand immigrant rights, and work for change that ensures dignity, equity, and full inclusion, not just for Chinese Americans, but for all marginalized communities. So I wanted to try and take a step back and understand the moment we're living in, especially for students, workers on visas, and all migrants and immigrants in the United States. California is often considered one of the most pro-immigrant states in the country. There are sanctuary policies in many of our cities, free legal services in some places, and laws that provide undocumented and limited English-speaking residents with greater access to health, housing, and labor protections. But on the ground, immigrants still face serious challenges: language barriers, fear of law enforcement and ICE, and a complex immigration system that can change with the stroke of a pen, and today with the order of an out-of-control president. Even in San Francisco, with our local protections, we see families separated, asylum seekers turned away, and workers exploited because they don't know their rights or don't feel safe speaking up. All this sits on top of a long history of exclusion and racism. And we really can't understand this moment without remembering that the US immigration system was built on racial exclusion. The Chinese Exclusion Act of 1882 was the first federal law to ban immigration solely based on race and nationality. It turned Chinese people into permanent outsiders, prohibiting them from becoming citizens, denying them the right to bring their family members, and subjected them to interrogations, surveillance, and detention. The law was explicitly racial, and its logic of suspicion, criminalization, and conditional belonging was not new to other communities of color, whether former slaves or Black or Native Americans who had survived genocide. Later in World War II, the mass incarceration of Japanese Americans based on ancestry without due process reinforced this logic. Entire families were forcibly removed and imprisoned, not for anything that they did, but because of who they were. And throughout the 20th century, immigration law has criminalized immigrants not based on where they come from, but what they say, what they believe, or who they are associated with. During the McCarthy era, thousands of immigrants were deported or denied entry due to alleged ties to communism. After 9/11, the US expanded immigration enforcement under the banner of national security, resulting in widespread surveillance, profiling, and detention of Muslim, Arab, and South Asian communities. Today, social media posts or political views about Gaza and Palestine are being used to justify deportations, revoke visas, and justify surveillance. So it's important to understand that this history isn't ancient, it lives in the present. And if we understand that, we can see how the systems we have to navigate are not neutral. They are shaped by decades of racial, political, and ideological exclusion. Layered on top of that is the current political relationship between the United States and China. A relationship that's currently marked by trade war, technological competition, and national security fears. This context matters. When geopolitical tensions rise, Chinese people in the US, regardless of citizenship, regardless of immigration status, are treated with suspicion. There's an active effort today to bring back the China Initiative, which puts scholars, students, and scientists, and tech workers under surveillance and subject to biased investigations simply because of their Chinese background. We are seeing a dangerous rise in racist anti-Chinese legislation across the United States. In Florida and Texas, they have introduced or passed new alien land laws that block Chinese and other immigrants from purchasing property. These laws do not target national governments, they target people and families. And though much of this is spawned out of racial, racist, political posturing, they directly impact the ability of all of us to live freely and fully in this country. So what does this mean for us? It means we must not only protect ourselves as individuals, but we also have to do it together. We need trusted legal and community systems. We need public policies that are shaped by our lived experience. And we need to understand that our value and the value of others is not through their immigration status, but as human beings who deserve to live with freedom and dignity. At CAA, and my colleague Jose will discuss this, we've done a lot of things in San Francisco that have built up stronger networks that offer free and culturally responsive legal services, that coordinate removal defense, that provide a 24/7 hotline for immigrants. We have other networks that help push the city to provide information in multiple languages, or to help non-citizen immigrant parents have a voice and a vote in school board members. All of this continues the traditions of other Chinese organizations in the United States. And that's what we need to continue to build. And that's what will need to happen here on the peninsula and in the South Bay and throughout the country. Now, everything that I've described happens through coalitions. But the coalitions are not just about numbers, they are about values. They're about multiracial solidarity. We have to stand with anybody who's treated as an other, whether because of their skin color, their religion, their immigration status, their orientation, their gender identity. And this is not a new idea. The US immigration law only became more just because of the Civil Rights Movement. The 1965 Immigration and Nationality Act, which allowed many of us to be here today, or our parents to come, was passed because of the struggles led by Black communities demanding justice and dignity. Frederick Douglass, the formerly enslaved abolitionist writer, who fought for the freedom of African Americans, also opposed the Chinese Exclusion Act. He saw clearly that if America could deny freedom to Chinese immigrants, it could not deny freedom to anyone. For him, the fight against racial exclusion was inseparable from the fight for human dignity. So that is our solidarity to carry forward. I'm going to close and get to the heart of what I think folks want to understand is how do they protect themselves? By quoting one of the founding documents of this country, the Declaration of Independence. It starts, we hold these truths to be self-evident, that all men are created equal. But of course, not everybody was included in that promise. Not women, not Black people, not Native Americans, not the poor. The contradiction between those words and the reality of exclusion has always been a part of this country. And it is our task to help resolve that contradiction. Created equal must mean created of equal worth and dignity. That's a belief not just for citizens, but for all people, regardless of immigration status. So that's what we are fighting for. Not just to be tolerated or protected, but to be fully seen, heard, and valued. So I invite you to learn what you can do to protect yourself. But remember, the most powerful protection will come from how we come together as a community around values that extend well beyond us. That will be how we build safety. That will be how we build power. That will be how we build the future that we deserve. Thank you.
So now let's welcome our immigration right manager, Jose, to introduce some of the local immigration right resources.
everyone. My name is Jose Ng. Thank you, Jinjia, and I also work at CAA with my colleagues being Pan. So basically, I'm going to keep it very quick. I'm going to share some resources, key resources that we have in the Bay Area. I know some of you coming here to this workshop might have some questions that you might want to ask immigration attorney, directly in a private setting. And here are some of the resources that we would like to share with you all. The first one that you find would be how to find an immigration legal service provider, especially trusted immigration attorney. You know, there's so many immigration attorney, out in the market, but how to vet them, how to, look for them. I mean, here are some resources that we would like to share with you. The first one that we would recommend if you can go online. I don't have the link here, but basically if you can search the American Immigration Lawyers Association, AILA, so they are a professional body, where they, basically it's a group of, immigration attorneys who practice immigration law, mostly focus on immigration law. I think Olivia Lee, she's going to share a little bit more. I think she's used to be the chair, right, of the, Bay Area, AILA, board. So I think the next one that you can see here on the screen is the Bar Association of San Francisco. I'm not sure about the Santa Clara County here where you guys are located, but I'm sure that they all have referral services. And here in San Francisco, the Bar Association of San Francisco, they offer a free lawyer referral services. So basically, you can go to the website and look for that area, particular area of immigration. So basically, immigration law, and then you can find those trusted immigration attorney. And for some of you, you might have questions, it might not necessarily have to go to, or maybe you're a student, you're thinking, oh, is there any low loan, basically free, immigration legal consultation that I could have? So here are the list of non-profit immigration legal services provided that you could look for. Some of you might not hear about Department of Justice. That actually they have a program called DOJ R&A, Recognition and Accreditation Program. So basically, it's a group of non-profit or church or organization who are not for profit, and basically they have to go through a process to get their organization certified. And so they have their non-profit worker, maybe they call themselves DOJ accredited representative. So they are also trained in a certain way to provide some sort of immigration legal services. So these are the websites that you could look for those. So they usually will provide free, low-bono immigration services. If they are under the DOJ R&A program, they usually have at least one DOJ accredited rep. So here, I would recommend you to go look for that DOJ R&A program, and then you probably could spot some even around this area. And then down there, that's another website called the National Immigration Legal Services Directory. This is a website they also consolidate all the immigration legal service provider in this particular area. So you can just go there and then look for them by your zip code. Yeah, take a photo, and we can. I think we can figure out a way to share the PowerPoint later on with you all, so you don't have to worry about that. And then next, we do have some regional rapid response hotline. How many of you have heard about rapid response hotline? Immigration rapid response hotline, can you raise your hand? So, sounds like not that many. Maybe I can explain a little bit more. So basically, right now, a lot of local, regional rapid response immigration hotline have been reactivated. Some of them, they do start operating during the first Trump administration. So what do they do? What they do may vary from one to the other, but the basic baseline services that they do provide is to provide immigration rapid response services. Basically, what if someone got picked up, detained by immigration authority, mostly ICE agent that you hear about them in different neighborhoods. If they have here community member calling them, the rapid response hotline, they would respond. But the services might be different. Usually it's response to those urgent contacts. Someone got picked up by immigration police, or we call them ICE, immigration and customs enforcement agents. So if you, some of them, they also provide great verification services. The San Francisco one, the one we help staff, we do provide rate verification purposes. basically, if you spot ICE here, let's say they're in Stanford campus, and you can basically call the hotline and then let us know, send a photo. And what we do is we will send volunteer to verify that whether that's rape happening there or not. And in that way, that's how we can share information out and make the community safe. Basically, it's create a community defense mechanism. So here we just have, I think, released a few, of the Bay Area regional rapid response network number, and some of them are operating 24/7 by the San Francisco one. So feel free to take a photo and then try to contact them, in case if those things happens. Yeah, I think I'm just keep it very quick. These are underneath it. You can find CA's online immigration community resources. So we do have some, key immigration takeaway resources that we would like to share with the community. I might not have time here. We usually do an immigration right training. For example, how do we respond to ICE when you encounter them at the street, or maybe at your workplace, at your home. But feel free to go to our website. We do have a lot of good information, updated information. We try to get it updated. And right now, it's being offered bilingual, so in Chinese and English. So I'm going to keep it here. Thank you.
Hi, can I have a question?
Yes.
I have heard of the Rapid Response Network, and I want to know, aside from reporting to this network, is the network keeping track of how many folks are taken? Is the network then able to actually respond in any sort of way? I'm not sure on that info.
That's a good question. So basically, we can go back to that slide. I can talk more about the San Francisco one. So we staff the San Francisco. We're part of the group staffing the San Francisco Rapid Response Hotline. So myself, I'm one of their dispatcher, basically the one responding to those calls. So what we do in San Francisco is when someone calls us, we would confirm it. Hey, are you or someone in your family being detained? It's an ongoing. If it's an ongoing ICE operation, what we're gonna do is we're gonna alert and activate our volunteer who live around that area, and then they are gonna go and check it out, whether that's ICE, conducting immigration enforcement or not. And they would take a photo, they would video, film it, and then if that's someone who is being detained and held by ICE in San Francisco, what we are going to do is, we're going to proceed to the second stage, that we're going to activate the attorney representation. So basically, we work with another group in the city. Basically, we just inform them, hey, here is someone we know that who is being detained in San Francisco. They detain people at 630 Sansom Street. So we're going to pass out all the information, the intake of the persons, the A number, the alien number, the name, the birth number, and all those details to the attorney. And then the attorney is going to provide a consultation. Basically, the attorney is going to show up probably within that day at the ICE detention facility in order to talk to the person who's being held there. So try to provide consultation to the person. Hey, about your right, which stage are you at right now? Because people might have different circumstances. So then basically that's how the network would work. One, if someone, or you are someone who's being detained, so you can get activated and call us, and that's how we can see and help you and support you. So yeah, that's the first scenario. For the data, we do collect data. So in San Francisco, I think I can share very quickly right now. So far, I think during the first few weeks of the Trump administration, we got a lot of calls. I think one single night we almost got 40 calls. But mostly, I think those calls are, most of them are not confirmed. Most of them are rumors, because there's a lot of rumors circulating around. Some of you might see those rumors, circulating on WeChat or Instagram. Those are not true. So that's also part of the message we share with people. Do not share any unverified information, because you're going to scare people more. People are not going to go to the street. But I think in terms of number, we had collect about probably 5 to 7 confirmed individual arrests in a week in San Francisco, compared to maybe during the Biden administration, it's probably 1 per week, per month. And then you can compare the number. It's basically skyrocketing in terms of people being arrested individually. Yeah.
Thank you.
Thank you. We definitely will have a QA section right after Olivia is speaking. So also we have a QR code. If you want to put your questions first, just in case later on when I open the QR and your question somehow didn't get answered in time, you can put your question right now during the speakers are speaking. So I give 1 second for folks to scan the QR, put your questions, and also if your questions are very private, it's not suitable to discuss publicly, we will also try to get back to you privately. Okay, so that's a QR code for questions. Also very quickly, 我现在呢切换成中文，那是因为呢，因为我这边辟谣吧呢，包括我们的微信公众号“美国华人杂谈”和华会的微信公众号呢，都会提供很多关于移民权利的中文资源，比如说这是上面列出来的一些入境被搜查盘问怎么办，包括移民身份相关的与 ICE 互动的一些权利。那么我们的我们的这个美国华人杂谈之前叫做正义补丁网站，也会提供很多就是跟移民相关的最新的新闻和评论。那么同时，就如果你还没有关注我们的2个微信公众号呢，现在又是一个扫码的时期。那么有很多的 QR。那么然后呢，如果你这边想要帮我们翻译或者帮我们做更多的这个，不管是评论还是视频，讲述你的移民故事，发出移民我们的声音，也可以联系我。Okay, I think I talked too much. Now let's invite our senior immigration lawyer, Olivia Lee, also our board member. Welcome.
Thank you, Jinsha, and thank you everyone here for attending. Can you hear me okay? Oh, wait. Sorry. All right. Okay. So I've got an hour, and I've always wanted to talk for an hour. Lawyers love to speak. My name is Olivia Lee, and I wanted to share a little bit about myself, just because when Vin shared earlier about the history of immigration and where we are now, I was really reflecting about what he was saying. My parents are immigrants. But if you look beyond that, my great-great-grandfather was the first to immigrate to the U.S., and then my great-grandfather immigrated to the U.S. They were not able to bring their family here, and so we definitely were directly impacted by Chinese exclusion, and also lived for several generations with families separated. And so my grandfather was the first to be able to bring his family to the U.S. As a family unit, and so I am the first in my family to be born in the U.S., and so I'm a birthright citizen. So I just wanted to reflect personally about what Ben was sharing about the history of immigration, how a lot of the things that we've seen in the past we're still seeing today, and we can still personally see that here. Also wanted to thank Chinese for Affirmative Action and the Bay Area Chinese Culture Salon for inviting me to this and presenting here. And I wanted to share that we are definitely in a very unprecedented, evolving and situation in terms of immigration. I've been practicing immigration for 17 years, I think. And as Jose shared earlier, I used to chair the immigration bar in Northern California in the first Trump administration. I now serve on the national board of the immigration bar. And this is the American Immigration Lawyers Association, which is a 17,000 member organization. We need more lawyers. There's so much work to be done. And if you know of any law students who's interested in immigration, they can get a free membership to the American Immigration Lawyers Association and get free access to resources, research, and things like that, because we need as much support to help all of the people facing just concerns, questions, detention, removal proceedings, many things that are out there. So just wanted to really emphasize that. I wanted to also mention that what I share here should not be taken as legal advice. This is what I am required to say, according to the State Bar. This is not considered legal advice. It's not considered advertising or solicitation. And also, because of the really changing and evolving situation that we're experiencing, if you do find yourself needing your questions, immigration questions answered, definitely seek competent legal services from places like the American Immigration Lawyers Association or the Bar Association of San Francisco, or any of the organizations that Jose shared earlier. Just an example of how quickly things are changing. I was researching things up until about 2 hours before this presentation on legal changes that had happened yesterday. So that's how quickly things are changing right now. So today, this is just quickly where we're going to, what I'm going to be going through today. I have 55 minutes. I'm keeping track of that 1 hour time slot I've given. I'm not going to read the slide, but this is just quickly where we're going to be going today. Let's go to the next slide. All right. So we wanted to first begin with a really general know your rights information. This is from a New York Times article that was published earlier this week. And we thought it would be good here because it's very clear visually what are some rights that are highlighted in this article. Now, just some things to note about the New York Times article. There's information as to what's impacted based on your immigration status or category. And then where there's a red circle, that's what the Trump administration is trying to change. So the first slide here is what rights do different groups have when arriving to the US? So this is when you come to the US, you have to stop at CBP, and what rights do you have? Could you be denied entry or detained while attempting to enter the US? And so there is this grid here that outlines the different scenarios. And then the next question is, could you be denied entry based on your public speech or social media postings? I think most people are very interested in this because we're seeing some changes here. According to the New York Times article, US citizens, no. Green card holders, no. Long-term visas, these are people like on H-1Bs, F-1s, no. Short-term visa, no. And then no valid visa, yes. So according to this article, there's red circles around the people who are holding long-term visas and short-term visas. And I think that another thing that happened, I think it was yesterday, it was, I'm sorry, it was not yesterday, it was a Wednesday. The Department of Homeland Security announced that they're going to screen aliens' social media activity for anti-Semitism. So that was just announced on Wednesday. And it was announced to be effective immediately and applies to lawful permanent resident status, foreign students, and, quote, aliens affiliated with educational institutions linked to anti-Semitic activity. So I think that this is definitely an area that's changing. And of course, as things evolve, we may see more activity there. Could immigration officers search your phone upon entry? It's yes on all of this. And we will be going through an electronic device search tips later on in this presentation. Which people can immigration authorities detain and try to deport? So again, there's this New York Times slide again. Could immigration authorities detain and seek to deport you even if you have not been convicted of a crime? So I think that folks here are thinking about like the situations of Mahmoud Khalil or the student from South Korea, and these were green card holders, and there have been recent activity in their legal cases. So Mahmoud Khalil, for example, yesterday there was a decision on his case in that the immigration judge in his case said that he can be found deportable based on his political speech, and so that's something to definitely be on the lookout for. So his case was before the immigration judge in Louisiana, and that judge said that there's nowhere in the law that says that the Secretary of State's findings on foreign national matters, foreign policy matters, can be overruled by an immigration judge. In his case, there's another part of his case that will be heard in habeas, a habeas case that will be heard in federal court, so there might be more activity there. So again, this is just a really evolving situation, and just want to make sure that people understand that while there have been long-standing rules and rights, we're seeing some of these rights really start to blur and sometimes even erode, and I think that we just wanted to make sure that you're aware that even though historically there are certain rights, especially for green card holders and people with long-term visas, we're seeing some definitely like grayness here, and things are ever evolving. And in this last week, and almost every day, we're seeing updates here. Okay, what due process rights do different groups have? So in this slide, are you entitled to fight your case against deportation in court to prevent your removal? So yes, in most categories, but you may have heard that this issue called being expeditedly removed. And being expeditedly removed, this is historically, before the Trump administration, it was a limited region in which people could be expeditiously removed. Now the Trump administration has expanded this to everywhere in the US. So it's not limited only to near ports of entry anymore. So in this scenario, if you are expeditiously removed, there's usually no right to defend yourself, and if you're expeditiously removed, you're barred from returning to the US for 5 years. So it is quite concerning. The other question here is, do you have the right to be represented by a lawyer in immigration cases? Yes, but the right to a lawyer is not at the government expense. So you must either find pro bono counsel or defend yourself, or pay for counsel. So there is a right, but it is not at the government expense. I also wanted to clarify that if you are subject to secondary inspection when you enter the U.S., so when you enter and are processed through CBP, you do not have access to counsel at CBP. You could call, you could possibly call, you can request for a phone call with an attorney. They may or may not grant it to you, but there's no right to counsel or access to counsel at CBP. And also, if you are going to the consulate or the embassy for a visa, there is no right to counsel in that situation either.
Can I ask who's subject to expeditiously being removed? Is it only the no visa valid category or everybody?
It is, so the question is who's subject to being expeditiously removed? It is almost all visa holders, and LPRs are not, I believe. LPRs are not, and definitely US citizens are not. So there's some protections for LPRs, but almost all other visa categories are subject to.
LPR stand for?
The question is, what does LPR stand for? It's a green card holder. It stands for lawful permanent resident. Let's move on to okay. I put this slide in here because I always get the question of what's a visa and what's a status, and these are concepts that we're always talking about in immigration. And so a visa when you're speaking with an immigration lawyer or expert, a visa is usually that sticker in your passport that allows you to enter the U.S. in that particular status. So that is a visa. It is essentially a travel document. It allows you to enter in whichever status of that visa when you enter the U.S. So when we're talking about visas, that is what we're talking about. And it will come, this issue will come into light later on when we talk about the F1s. The other issue is like, what is a status? So when you enter the U.S., you're granted status. So if you're an F1 student, you're granted F1 status. If you're an H1B, you're granted H1B status. And there is an expiration date typically on your status. So in this example, it's in L1, and the status is actually granted by CBP when you enter. So in this situation, CBP will issue an I-94 card. And this person, Lydia, was granted L1 status through, she said this is not an L1 status. My slides are really tiny. This person was granted B1 status, and she was admitted through October 10th, 2012 in B1 status. So when you enter, you're granted this I-94 card by CBP, and your status is what's granted through the I-94. If you apply for an extension or a change of status with USCIS, you're granted a new I-94 through the USCIS form, I-797, and there's a new I-94 card right here. And then, so this person will be granted an extension or change of their status through the expiration of the I-94. And so that's status. So I just wanted to clarify that because we get a lot of questions asking, like, what's the difference between a visa or status? And people use those terms interchangeably. I just wanted to clarify that. Very quickly, I think that a lot of us maybe have entered first as a student F1, and so the natural next step to work in the US is through the H1B. So just wanted to quickly go through the H1B. H1Bs are subject to a quota. There's 65,000 H1Bs available each year. 6,800 of them are reserved for Chileans or Singaporeans under a visa type called the H1B1. And then 20,000 additional H1Bs are provided for students with US advanced degrees or higher technical degrees. Because of the economy and the demand for the H1B, there's oftentimes more demand than there is visas available, and so every year we are usually seeing a lottery. The only time I didn't see a lottery was in 2009 because of the financial crisis at the time, and every year thereafter we were seeing a lottery. The lottery is run in March every year for an October start date. So we just went through a lottery earlier this year, just a few weeks ago, and we are now working on those that are selected in the lottery and will get H1B status as of October 1st. If people are not selected in the lottery, these are some other options to consider. E3s, TNs, H1B1s, these are available year-round, but some of the issues with these visas is that they don't have dual intent, they're singular intent visas. And if folks have questions about this, I can answer that during the Q&A. Another visa type is the O1, which we call the Einstein visa. These are for people with really rock star, extraordinary ability type of backgrounds in science, education, business, arts, or athletics. There's also humanitarian programs, and green card could be an option in some situations. And then another option that we frequently talk about is perhaps going back to school for the F1 students. and then very quickly, this is just some high-level information about green card categories that are employment-based green card categories. So there's EB1, which is usually reserved for people of extraordinary ability or outstanding research. EB2, which is for employers that require a master's degree or higher for the position, or the position requires a bachelor's plus more than 5 years of post-baccalaureate experience. And then there's EB3, where the employer requires a bachelor's or 2 years of experience. All right, now for those who are in work visa statuses, I really wanted to go through this slide to went through like a really quick background of the most common type of work visas, and also how to be selected for lottery and options. So this slide is about change in job situations, and I really wanted to emphasize this because as an attorney, I always see the issue come up after the fact, and we have to fix the issue. And I think that if you know of certain changes that are happening in your job, and if you're on a work visa, please let your attorney know, because some of these things require a filing with the government, and if a filing with the government doesn't happen, it could mean that you're out of status. Okay. So the first one is changes in job locations. So a lot of work visas are location specific. So H-1Bs, H-1B1s, E3s, if you're on a STEM OPT, which is the F1, and J1, these are all location specific visas. Before your job location changes, please contact your immigration attorney or your employer so that the right things can be done in case a government filing needs to be filed. For those, that's just kidding. For those who are remote working, and if you have the ability to remote work, and if you are going to move from apartment A to apartment B, let's say it's across the hall, you still need to inform your immigration attorney. Some of these jobs are very location specific, especially H-1B, H-1B1s, and E3s. If you're moving, down, like I said, across the hall, or down the street, in the same city, inform your attorney so that they can advise on how it will impact your immigration status, and make sure to inform them in advance. The impact on PERM, so PERM is the green card process, related to the green card process, and that is a test of the US job labor market. So PERM is also a location-specific application. So in this scenario, there might be some impact on the PERM, especially if the PERM hasn't been filed yet with the Department of Labor. Another change in job situation is if you have a change in job titles or job duties. This happens with a promotion or a demotion. So it may impact any of these visas that are listed here, the H-1B, the H-1B1, or the E3. In this scenario, if it is a change in the occupational classification, that will impact your immigration status. So if you go from an engineer to, say, a marketing position, those are definitely two different types of occupations, and will require some legal strategy in order to make sure that you're in compliance with your immigration status. For a TN, that may also be impacted because TNs are also large swaths of occupational categories. So if you go from, again, an engineering position to, say, an analyst position, a marketing analyst position, that is also a change in occupation. And so, again, if you do have a change in your job title or job duties through a promotion or demotion, or just a complete change in occupation, definitely contact your immigration attorney. Another issue that we constantly see is these questions about employment termination. So over the last few years, we've definitely seen issues of layoffs, reduction in force, and things like that. And so some of the questions that we regularly get is like, well, can I stay in the US? What can I do? And so certain types of visas do get a 60 days grace period, assuming that your I-94, the status that you're granted is beyond 60 days. So if you are, let's say I was let go today, right? And my I-94 card expires in 30 days, okay? Do I get the 60 days grace period? No, because I only get up to 30 days because my I-94 expires in 30 days. So even though these visa categories can be given the grace period of 60 days, there's a caveat as to whether or not your I-94 will expire. For F1s, if you are an OPT or STEM OPT, you have up to either 90 days of unemployment, that's in the aggregate, as a 12-month OPT worker. If you're in the 24-month STEM OPT period, you have 150 days of unemployment. That is in the aggregate. So let's say you got your OPT card 2 years ago, but you weren't able to find a job for 30 days. Those 30 days of unemployment that you were not able to find a job get added to your 90 or 150 days. For CPT, some people are in the U.S. on the F1 CPT and working on the CPT. Contact your international student office right away if your employment has been terminated, because CPT usually is, as a requirement of CPT, you need to be enrolled in school, and then you're usually under some work-study agreement or work-study contract with your employer, and so that may change your enrollment situation with the school, so definitely contact the school there. Another question that we get is, well, my employer has given me a garden leave or severance payment. When does my 60 days of grace period begin? Or when does my 90-day or 150-day of unemployment under F1 begin? So that is a question that is very gray in the law, and definitely work with your immigration attorney in strategizing that. If I were handling that case, it would depend on the documentation that the client was giving me. So usually, with immigration status, especially for work visas, we look to the pay stubs. So is someone getting a pay stub, and that's how we know they're still working in their H-1B or F1 or TN, or whatever status they're in. For severance payments, sometimes what we see is the pay stub will look like a normal pay stub. It will look like just like any other pay stub. Those won't trigger any flags. Like those look like pretty regular pay stubs, and I think that it's arguable that they are clearly maintaining status because the pay stub looks like a regular pay stub. But if the pay stub indicates severance pay, then that's a clear indicator that person is on severance pay period. So it really depends on how that employer will be issuing the pay stubs after the employment termination, and in this garden leave period or severance leave period, how the pay stubs will look. The law is actually very gray here, and we have memos from U.S. immigration conflicting each other, so that's why we can never guarantee that the later date of the garden leave or severance period will be the date that the 60 days grace period or the unemployment period begins. All right, some other things to highlight in terms of change in job situation. If you have a decrease in pay, that may also impact certain types of visas, the H-1B, the H-1B1, E3, and the PERM. so it doesn't impact the other visas we mentioned, the TN, doesn't usually impact the F1. We didn't talk about L1s, but there's this odd caveat for L1s. If anyone here is on an L1, I can talk about that later. And then for layoffs and reduction in force, just wanted to let folks know that if you are on any type of visa that has an LCA, so those are the H-1Bs, the H-1B1s, and the B3s, the employer cannot bench you. So the employer cannot place you on mandatory unpaid leave if it's not on your volition. The H-1B does require the employer to pay you the wage stated in the H-1B petition filing. The other thing about layoffs and reduction in force, there's certain layoffs of certain sizes, so if they're really large layoffs, the employer is subject to a WARN Act, which means a 60 days notice period, and it depends on the size of the layoff or the reduction in force, so that's something that also consider. And then if the employer does go through a layoff or reduction in force, it may impact their PERM green card program. So when a company goes through a layoff, any of those occupations that were impacted by the layoff, if the employer is going to be using that occupation to test the U.S. job labor market, they cannot do so for 6 months. So COOL's PERM for 6 months if that occupation is impacted by the layoff. All right, so here's probably something more interesting, more relevant for today is the current administration. So the current administration, as we all know, they've it's been less than 3 months and hundreds of changes. The first day of the Trump administration, there were a number of executive orders that were issued that kind of paved the way for some of the changes that we're seeing now. On the first day, these are just 5 executive orders. There were many more that were issued. There was the rescission of Biden-era orders and actions. And so in the Biden administration, he had issued executive orders that promoted family reunification and refugee resettlement. And so the rescission of these orders from the Biden administration set the stage for the expansion of expedited removal in the interior. It sets the stage for eliminating the right to seek bond and reinstating the public charge process, which was part of the Trump 1.0, we're no longer in that in the public charge situation of Trump 1.0, but immigration attorneys are getting ready to for the return of the Trump era public charge issue. The second executive order that I highlighted here is protecting the meaning and value of American citizenship. So this includes stripping the fundamental right of U.S. birthright citizenship if a child is born in the U.S. to a parent who is unlawfully in the U.S. or is temporarily in the U.S., such as the H-1B. So this executive order is the attack on U.S. birthright citizenship. It's under federal litigation, not currently effective, but there's definitely a threat to U.S. birthright citizenship because it's still tied up in the courts. The third executive order is protecting the American people against invasion, which is the basis of the new alien registration requirement, and again, the expansion of expedited removal and restricting humanitarian parole and TPS. So these are, again, all January 20th. It was setting the stage up for the things that have been coming since then. Protecting the U.S. from foreign terrorists and other national security and public safety threats. And this sets the stage to justify a travel ban and enhance vetting of visa applicants. And then finally, designating cartels and other organizations as foreign terrorist organizations, especially designed globally terrorists. And this sets the stage up for using the Alien Enemies Act to detain or deport individuals, which is what we saw earlier this year. So again, these were numerous executive orders that were issued on the first day of the president's, when he took office, and it gave a precursor to many of the issues that we're seeing today. Okay. This is, so one of the issues, one of the new policies from the Trump administration is the alien registration requirement. And this is where a person is required to register if they are in the US, over 14 years old, have not previously been fingerprinted or registered when applying for a US visa, and who remain in the US for 30 days or longer. This was announced on February 25th of this year. And there was a lot of confusion when it was announced because the rulemaking process was not followed. So again, February 25th was when it was announced, and they said it's effective immediately. Then on March 12th, a couple weeks later, we finally get the announcement in the Federal Register, which is the normal path to rulemaking. And since that time, there has been multiple organizations that have been challenging this requirement. So one of the ways that the organizations, this is a coalition of nonprofits and different immigrant rights organizations, one of the ways that they've been challenging this is challenging the rulemaking process. They did not follow the rules, this should not be lawful. The second way that these immigration rights organizations have been challenging this is through federal litigation. So there was a federal litigation case that was filed back in March, and there was a ruling that just came out April 11th, which I think was yesterday. And I'm sorry, it was Thursday that the ruling came out. And the ruling that came out in that federal litigation was that these immigration rights organizations do not have standing, they do not have the ability to sue. So that means as of yesterday, this is now the requirement. So this is now a requirement. There are many people who are exempt from registering. So please take a screenshot of this, and if you have more questions about if you're required to register, we can talk about that in the Q&A. With the alien registration requirement, there was a reminder of this rule to carry your documents. So this is actually, it's in the Immigration and Nationality Act that all foreign nationals who are over 18 years old must carry documentation of the registration as a foreign national while in the US. And these are the types of documents you need to carry. And this is actually, this predates the Trump administration. It's actually written in our Immigration and Nationality Act rules. But the regulations and the law do not state that you must show the documentation, and as it just says that you must carry. So when this alien registration requirement rule came out, more organizations have been saying, oh, reminder, this law exists. So, you know, because it's stated in the law, I think you're seeing more and more people advising on this requirement. But again, you do not need to, the law doesn't say that you need to provide the documentation if asked. And I also wanted to, since we're talking about archaic immigration rules, I also wanted to remind folks that if you do move residential address, you have to inform immigration within 10 days. This applies to everyone who is not a citizen, so even green card holders, definitely people in visas. So everyone who is not a citizen is required to report to immigration if they move within 10 days. Okay, F1 visa revocation, CVIS termination. I think that this has been garnering a lot of attention over the last few weeks. beginning on January 20th, again, that first day that President Trump was in office, he issued an executive order called Protecting the U.S. from Foreign Terrorists and Other National Security and Public Safety Threats. And this really set the stage for more enhanced screening and vetting. Since that time, we've seen high-profile arrests of international students, some related to political speech, and then after that, on March 27th, our Secretary of State Marco Rubio reported that the Department of State revoked more than 300 F1 visas. So since that time, we've been getting a lot of reports. I know that I understand there's a Reddit mega thread that has a lot of information. I'm not sure how credible that information is, but they're reporting probably closer to over 1,000 students have been impacted. There's just been a lot of activity here. And I think that what I wanted to share was that there are two issues we're seeing. The first is the Department of State has been informing students that they're revoking visas. So again, going back to that earlier slide of the visa sticker in your passport, this is what we're talking about, that visa sticker. So if you are here in the US and the Department of State has revoked your visa, it does not impact your status. It impacts your ability to use that visa to re-enter the US. So that means if you are here, you don't need to depart just based on a Department of State revocation. Department of State revocations have happened before the Trump administration. They happen sometimes when people, have a DUI arrest, and then while they're here in the US, and then the Department of State catches wind of this, and then they inform that person on the visa that their visa has been revoked. So again, it does not impact your status, it only impacts the visa. And that visa is the ability to re-enter the US. The second issue that we're seeing with the F1s is ICE going into the CVIS record and terminating the CVIS record. This is where it's the area of law is grayer. So the question is, does that impact your status? In that area, there's two lines of thoughts here. I'm a member of the American Immigration Lawyers Association. I was just in Washington, D.C. last week among many immigration attorneys, and we were talking about this F1 situation. And there are two schools of thought here. And again, it's evolving, it's gray, we're not sure which school of thought will prevail. One school of thought is that if your CVIS record is terminated, it doesn't impact your status because CVIS is just a platform that marks whether or not someone is in school, can enroll in that school, and so forth. So there's one school of thought that says, no, it does not impact your status. And in this school of thought, they're referring to a 2009 memo from USCIS that F1 students, they are granted duration of status. So when an F1 enters the US, their I-94 is given a D/S, that means duration of status. And because of that, they're here lawfully until they're done with their F1 studies. And in that memo, it says that the F1 student does not become unlawfully present in the US until there is a finding by either an immigration judge, so that requires the person to be in the immigration court, or through a USCIS notification that they are no longer maintaining status. So that is one line of thought, that the F1 CVIS termination does not impact the status. Another line of thought, though, is that it does. And some DSOs are saying that the student should not return to school, that the student must depart the US within a certain amount of time. And so that's just another line of thought. So again, this area is still evolving and it's gray. We're hearing a lot of different things here. I think that in terms of, I was looking this up today, as of today, there are definitely numerous cases filed in federal court. There's one class action that is being requested for F1s with CVIS terminations and DOS revocations based on criminal charges. So these are for the F1s who seem to have criminal charges at some point in the past. And so there is one court filing that is requesting the court to grant class action there. There was another decision that came out earlier this week where the federal judge granted a temporary restraining order to temporarily restore the F1 status of a Dartmouth student until the court makes another ruling in a few weeks. So, you know, as we're hearing a lot from F1s, you know, they're asking, what can we do? Again, I just want to emphasize it's really evolving, the situation is evolving, and I think that in like the next couple of weeks, we're probably going to see more updates on this. We get the question of like, well, should I file federal litigation? We do know that it's very costly to file federal litigation, and that many of the attorneys that are doing this type of work, they're private attorneys, and so there is typically some sort of cost there. So, you know, and the group that's impacted here, they're typically students. They may not be financially resourced, and so many immigration practitioners we're trying to put our heads together as to like what can we do. And again, I just want to say that I think in the next few weeks there will probably be more information that will be coming out on this. Okay, travel. Okay, another line of questions that we're getting over the last few weeks, few months is, can I travel? And this question is coming from U.S. citizens, it's coming from green card holders, it's coming from all types of people. People are really concerned about traveling, and so we want to just distill some of the frequently asked questions that we're seeing about travel. Is there a new travel ban? Not yet, or not so. There have been rumors of a new travel ban, and on March 14th, the New York Times did put out an article about a potential travel ban that was supposed to be issued sometime in March, but of course we're now in April and that has not happened. On this slide is the list of countries that would have been impacted according to that New York Times article. There are 3 different categories in the proposed travel ban. One is that all travel is banned in that first column, the countries indicated in the first column. Visas are restricted in the second column. And then the third column is there will be 60 days to review the concerns of countries listed in the third column. So again, there is no travel ban, but there were rumors of one, and the New York Times indicated this information in the March 14th article. Another question that we get is, I have a valid non-immigrant visa, such as the H-1B, and I need to travel internationally for business or personal reasons. Should I cancel my trip? And we get that question a lot right now. I think that everyone planning to travel internationally should take precautions and prepare for the possibility of any sudden changes in travel conditions. If you should take extra precaution if you're a citizen or national of any of those countries that were subject to entry restrictions in the past or are anticipated to be in the future. So that slide previously, if you're a national or citizen of any of those countries, you should probably take some precautions. Or if you're if you are a national or citizen of a country previously subject to travel restrictions, you should probably take some precautions. If you have previous criminal history, including arrests, citations, criminal charges, or convictions, even if the charges were dropped or records were expunged, probably take some precautions there, because we are seeing in the F1 situation, some of the F1 students who have had their visas revoked, they do not have any sort of criminal conviction. It is just an arrest. Some of them with arrests have all their charges dropped, and so just be careful of that. If you've participated in protests, written blogs or articles on political topics, or posted photos of protests and political statements on social media, definitely take some precaution there. And then wanted to highlight the January 20th executive order that directs the authorities to screen foreign nationals to the maximum degree possible and targets individuals who support hostile attitudes towards U.S. citizens, culture, government, institutions, or founding principles. So it's very broad. And then again, earlier this week, there was the DHS announcement related to anti-Semitism. So definitely take some precautions there. And then if you are not a national or of a previously or anticipated banned country, and you possess a U.S. non-immigrant visa and other required travel documents, your risks of traveling and coming into issues are lowered, but it is possible that you may encounter more intense screening with CBP when you enter the U.S. Okay, what kind of screenings can travelers expect at the airport, at the port of entry? So going back to that, the January 20th executive order, there's the heightened screening and vetting. So it directs government agencies to develop enhanced security screening standards and procedures that are compliant to that executive order. All foreign nationals who apply for visas at the consulate or for immigration benefits or admission to the U.S. are subject to security screening. So you may encounter questioning about various aspects of your professional background, your employment status, and the purpose of your travel. And then the CBP officer at the airport or the port of entry can send the traveler to a separate interview area known as secondary inspection for additional questioning, and all persons, including U.S. citizens, are subject to searches at the airport or port of entry, and CBP may search your luggage and electronic devices. What should you do if you're sent to secondary or detained at the airport or the port of entry? So secondary inspection, sometimes it's just a few minutes, and sometimes it's much longer than that. So it's really difficult to determine how long you'll be in secondary inspection. We suggest that you definitely remain calm and patient and answer any questions that CBP has truthfully. You don't need to volunteer any information if you're not asked. So only answer the questions that are presented to you. And if you don't understand a question or information that's presented to you, request for clarification. So sometimes what happens is you might be given like documentation to sign off on. If you do not understand that, definitely request for clarification, or if it's in a language that you do not understand, ask for that to be translated to you in a language that you understand. Do not sign anything that you don't understand. You don't need to volunteer any information, so don't volunteer information if you're not asked that. And the other thing is that you definitely should not provide any false information to CBP. And omitting or misrepresenting information can result in a denial of entry or removal from the U.S. So there's more information on here. And I know I have 6 minutes left, so let's keep going. What should I know about electronic device searches? Okay. So CBP, like you said earlier, they can search your devices without a warrant or reasonable suspicion. And if you refuse, CBP can seize your device. So here are some suggestions as to what you can do if you are planning to travel with an electronic device. We recommend that you travel light, and this means carry only necessary devices. There's a major immigration law meeting in Mexico happening right now, and many of the immigration attorneys there have said that they're seeing a lot more burner phones. So we're definitely seeing that being suggested, and people are actually using more burner phones nowadays. Consider using a dedicated travel device with minimal personal data, such as a burner phone. Backup before you travel. So save important files securely in the cloud on an external drive before traveling, and keep backups separate from your laptop or your tablet or your phone. You can also have password security, so secure devices with unique and secure passwords. And although biometric locks are convenient, they are considered less. We needed a little bit of an energy boost. We're talking about electronic device searches. So password security, secure devices with unique and secure passwords. And although biometric locks are convenient, they are considered less secure than a strong password. And two-factor authentication can provide an additional layer of security. Know your rights. You are not required to share your passwords with CBP, but refusal may lead to the device seizure and denial of entry for the foreign national. And then U.S. citizens can refuse to answer questions beyond identifying travel details. And lawful permanent residents, which are green card holders, cannot be denied entry, but may face additional scrutiny and delay. Visa holders may be denied entry if they refuse to answer questions. If your documents are searched, if you are searched, document the search. So write down details of the search, including the names and badge number of the CBP agents and the questions they asked. If your interview was recorded, ask for a copy of the transcript. Another tip is minimize your stored data. So carry less data across the border. Consider traveling with a laptop free of sensitive data or apps that collect and store sensitive data, or securely delete your files. Consider traveling with a temporary phone and then transferring your SIM card or getting a new number at your destination. Another tip is encrypt your device. Enable full disk encryption on all your devices for added security. Use a strong passphrases instead of simple passwords. You can also turn off devices before border crossing. So I don't know, like if you're like me, I like to watch a lot of movies when I'm on a plane, so I would just drain my battery. Power down your devices completely before reaching the border to help protect against potential remote access attacks and data interception. So that's another tip out there. Inspect devices upon return. So if your laptop is confiscated and later returned, boot it using an external drive and perform a thorough scan for any unauthorized software or changes. And then also on your device that you're crossing the border with, limit cloud access. So the border search will only examine information on the device at the time of the search and cannot access information stored remotely. So sign out of your sensitive apps, disable automatic logins, consider removing apps that store personal data, and then additionally, you may consider using a VPN for electronic devices. So those are some tips. So interacting with CBP agents, make sure to be honest, always tell the truth, never lie to CBP officers, and like I said, you don't need to volunteer any information. I really emphasize that one. Don't overshare. Stay calm and do not argue or interfere with the inspection, and acknowledge CBP's authority. Understand that CBP has the authority to physically inspect electronic devices while you are not required to provide your passwords. Refusing to do so may result in possible consequences such as device seizure or denial of entry, or just a really frustrating time with CBP. So that is the end of this Know Your Rights portion. And we'd like to open this up to Q&As from the audience.
Okay, thank you so much. Can I ask, do we know how often refusing to give the password will result in?
Can I ask how often does refusing to give the password will result in device seizure or rejection of entry?
I don't think there's any like data collection statistics on that, but I think that just anecdotally, if CBP is asking for the device and